want to talk today about what I call inventing the court, and it's establishing the federal judicial system. This is the court's home in the Constitution, Article 3, which is very short. Lindsay on Monday talked about how short Article 2 is, and it is short, but it does have specific enumerated powers. Like, the president is the commander-in-chief of the armed forces when called into actual service, because it says that in Article 2. That he has the right to nominate justices and ambassadors because it says it in Article 2. He has the power to pardon because it says that in Article 2. So there are things that are said in Article 2 that sort of specify the outlines of executive power. And as Lindsay demonstrated, Washington tried to fill in some of the gaps and sort of flesh out the office. If you look at Article 3, it's the orange area here. That's the judicial article. In proportion to the rest of the article, the green is the executive, and the red is Article 1, Section 8, or Article 1, which deals with Congress's powers, because the framers thought that they were crafting a legislative dominant system. Time changes all things, okay? But the court's powers were not particularly clear, okay? So let's take a look at the judicial article. And those of you who have seen me before know this line, but it's true. They tell you when you go to PowerPoint school not to throw up large blocks of text on a screen. I never went to PowerPoint school. As you're discovering now, I never went to Zoom school. I just went to normal school. But the reason I throw this text up is A, it's important, but also B, you have this PowerPoint, and this is public access stuff. You can cannibalize anything from this presentation for use in your classes. So when there are large blocks of text, it's in an effort to help you out, as opposed to just filling up a screen with large blocks of text. Okay, that said, Section 1 sets up, or frames, the context in which the court develops and the judicial system develops, all right? Now, judicial power of the United States shall be vested in one Supreme Court and in such inferior courts as the Congress may from time to time ordain and establish. Doesn't say how long, or doesn't say how many justices will be on the Supreme Court. That's determined by the legislature, and that takes you to the FDR court pack and things like that. But Congress has the power to populate the Supreme Court and to set up lower federal courts. So the federal court system, and this isn't addressed in many of your TEKS items, but it's just good to know because students will ask. The federal court system is created by Congress, and it was created by Congress in the Judiciary Act of 1789, okay? The Judiciary Act established 12 district courts, federal district courts, one for each state, okay? There were only 12 states at that time because Rhode Island was being Rhode Island. Section 25 of the Judiciary Act gives the Supreme Court, or gives Congress, in Section 25, Congress gave the Supreme Court the power to review decisions of state Supreme Courts that touched on federal or constitutional law. Okay, so that extends the jurisdiction of the court. We'll come back to that in a second. Today, this is still the same basic framework of the federal court system. There are 94 federal district courts, okay? Each state has at least one. So, to finish out the federal district court system, or federal court system, the Judiciary Act of 1891. This established for the first time permanent courts of appeals. So, like California, Hawaii, Oregon, and Washington State are in the Ninth Circuit Court of Appeals. Texas happens to be in the Fifth Circuit Court of Appeals. These are courts that are for the first time populated by permanent judges. These are courts that hear appeals from federal district courts. So if somebody thinks they got a raw deal in a federal district court or the law is misapplied, they appealed to federal courts of appeals. But there was not a standing body of the federal courts of appeals until 1891. Before 1891, appeals were heard by panels that were put together on an ad hoc basis of district court judges from that circuit and a Supreme Court justice who rode circuit. So much of the Supreme Court's justices' time in the first 100 years or so of the government under the Constitution was spent riding circuit. They would go out to their specific circuit and hear appeals with two federal district court judges. So that's the structure of the federal court system, okay? That's all Section 1 of Article 3. Section 2 says the judicial power, okay? So this defines, to the degree the Constitution defines it, which isn't very much, and that's the cool part about all of this. This defines the scope of judicial authority, okay? The judicial power extends to cases, law, equity, etc. You can see the big block of text there. To cases affecting ambassadors, all cases of admiralty and maritime jurisdiction, and then to controversies. So this is the home of what is called the Cases and Controversies Clause. So judicial power extends to cases and controversies, okay? But the thing is, it doesn't define what judicial power is. It just says whatever it is, it extends to cases and controversies, okay? This is the second section of Section 2 of Article 3. And it's crucial to Marbury, which is why I toss it up here. It establishes the court's jurisdiction. Jurisdiction is the power to decide cases, okay? The court has two kinds of jurisdiction. Original jurisdiction, where it acts like a trial court, and then appellate jurisdiction. And the appellate jurisdiction is where it acts like a court of appeals. So appeals would come up to it from the federal district courts, and if they involve federal or constitutional questions, from state courts. Original jurisdiction involves cases affecting ambassadors, public ministers, councils, and those in which a state shall be a party. So if Texas and Oklahoma are bickering over the boundaries of the Red River, for example, that case goes immediately to the Supreme Court, because here you have two quasi-sovereign entities debating, and it goes to the Supreme Court of the United States. Appellate jurisdiction is created and regulated by Congress, okay? That becomes important in Marbury. Let's see here. And then the third subsection, trial by jury, and the like in federal cases. Okay, so what made the Supreme Court supreme? And we'll look at some of these documents in about an hour and a half. But the Supreme Court essentially defined its own scope of authority, much as Washington defined the scope of executive authority. So, the judicial power of the United States shall be vested in one Supreme Court. Article 6, the Supremacy Clause, says that the Constitution and laws passed pursuant to it, laws that are consistent with it, are the supreme law of the land, okay? So whoever interprets the law interprets the supreme law of the land. And then Federalist number 78, which is not part of the Constitution, but is part of the Federalist Papers, and it was written by Alexander Hamilton, and I have to drop Hamilton's name because I get royalties from Lin-Manuel Miranda every time I do. Hamilton's Federalist number 78 explicates the role of the court, and it specifically says the court has the power to, let's see if we can do this, whose duty it must be to declare all acts contrary to the manifest tenor of the Constitution void. Okay, so Hamilton assumes that the court has the power to strike down legislation that is unconstitutional, that is not within the authority given by the federal Constitution. The problem is that's not in the Constitution, okay? So that's not in the Constitution. How does it get to be the signal power of the Supreme Court? Because that's what makes the Supreme Court ultimately supreme. And the answer to that is John Marshall, okay? You will hear him referred to as the great Chief Justice because he established everything that the court sprung forward from. He was a great constitutional force. His interpretation of the document held sway in some senses to this very day. He was also a great creator and steward of the power of the court, okay? And so what we're going to focus on for the rest of this discussion is essentially Marshall's contribution to American constitutional law. Now, one of the things, you guys have a much more difficult job than I do. SMU draws pretty good, in fact, very good undergraduate students. So in the grand distribution of all students, I've got the tail of the distribution and the high achieving tail of the distribution. You have the entire distribution, and you also have students who have significant constraints on their capacity to learn in terms of poverty, home situation, language skills, and the like. And I fully understand that. So the question, but one common thing that we have in together is, how do you get students to be interested in this stuff? How do you make it relevant to them? And part of the way you make it relevant to them, I think, and what I've tried to do myself, is to capture some encapsulating themes and then jazz them up a bit, or wrap them up a bit. That's the Miranda thing. So what we're going to talk about today is Marshall establishing judicial power and advancing certain constitutional goals. Judicial power, number one, okay, because without judicial power, he can't do anything. He has to have power. Secondly, national supremacy. And third, property rights, okay, protecting property rights. Those are his constitutional goals. And he achieves them in his time. Some of them lapse over time. The one thing that never lapses is judicial power, okay? So those are constitutional goals, but they're also political goals, okay? So he's involved in creating this niche for a court in a brand new government in a context which is not really favorable to him, okay? So you're talking about the politics of separation of powers because he has to relate to Jefferson and presidents after Jefferson, the Congress, which is now held by Republicans and will be forever, or at least throughout the course of the bulk of his life. So you have to deal with the politics of separation of powers, but you also have to deal with the limits of judicial power. That's reality. Because as Hamilton says in Federalist number 78, the court has neither sword nor purse. It simply has the power of judgment. It can't execute its own decisions. So it's in a context where it's constrained. Its capacity to exercise authority is driven by and large by its capacity to be persuasive, okay? All right, so how do you tell this story? How do you make it interesting to students as opposed to just some old dead white guys who haven't been around for a long time? You Hamiltonize it. Students now, and this may be ebbing out, I don't know what the current popularity of Hamilton is among folks the age that you teach, but still people that I teach, for example, have some attachment to Hamilton and know the music. And because of that, they've learned an enormous amount about American history. They know players. And it's compelling. And it's compelling not just because Miranda is an exceptional artist and lyricist and musician, composer. It's because the story of Hamilton is an interesting story, okay? It's fun. So how do we make the story of the creation, the establishment of the judicial branch fun, okay? Well, you tell the story the way the story played out, because there was nothing necessary about the court developing the authority and the power that it has, okay? Just think about what it's done today, or this week, right? You had the DACA decision on Monday, and yesterday you had the decision about, what was it? It's a Trump decision. I'm blanking right now. But it's playing in the American political game, and it's doing so because it has staked out that position. Okay, it has staked out that position. Yesterday was DACA. The earlier one was the LGBTQ discrimination case. Okay, so how do you make the story interesting? You tell it the way it happened, the way it came down. Okay, not in the room where it happened, because it happened in a lot of rooms, but in the context in which it happened. Okay, so the court starts off with no formal office. Okay, it doesn't have a building of its own. It finally gets a hall, room in the Congress after the Capitol moves to Washington, D.C. For the first 10 years, it has 3 chief justices. Okay, Denver had some George Washington paraphernalia that he flashed the other day. That's John Jay. Okay, he's the first Chief Justice of the Supreme Court. Okay, this is John Rutledge, the second Chief Justice of the Supreme Court. And this is Ellsworth, the third Chief Justice of the Supreme Court. I have all the Chief Justices. So there are 3 Chief Justices in 10 years. And the question is why? And the answer is because it was a terrible job. It was a boring job. They didn't really have much to do. And most of their time was spent riding circuit, which isn't particularly pleasant in the late part of the 18th century. Roads aren't very good, food's not very good, accommodations aren't very good. I mean, it's just not a particularly pleasant way to spend your life. So you go through 3 Chief Justices in 10 years. Okay. The one time the court made a truly significant decision is a case called Chisholm v. Georgia, which involved whether or not Chisholm could sue Georgia for payment on services that he had rendered to Georgia. He sued Georgia in federal courts. The Supreme Court said, yes, Georgia has to pay Chisholm. Congress came back, and then the states ratified the 11th Amendment, which says a state citizen from one state can't sue another state. So they overturned the one Supreme Court decision that had some real significance in that first 10 years. So, I mean, who wants to do this job? John Jay, when Ellsworth retired at the end of Adams's presidency, Adams offered the Chief Justice position to John Jay again, noted Federalist from New York. And John Jay turned him down. And he said the court will never have the energy, weight, and dignity needed to be a co-equal branch of the national government. I don't want this job. That changes in 1800. And it changes because of this guy. I'll give him full credit. That's John Marshall. So what happens in 1800? And again, this is part of the Hamiltonization of this stuff, because law and politics have always been fused throughout American history, sometimes more prominently than others. We're living in one of those times now, but they've always been fused. Jefferson's elected president in 1800, the Revolution of 1800. Republicans capture the House and the Senate, and the Chief Justice resigns, okay? There is a lame duck Congress until March of 1801, when Congress and Jefferson come into power. In the period between November and March 1800 to 1801, the Federalists get busy, okay? They're on their way out the door, but they're trying to preserve the power that they've got. They at least have a baton in the side of the mountain from which they can start their climb again to overcome this revolution of 1800, and they never climb back out of the hole. And that's part of the thing that makes Marshall so intriguing. All right, so on the way out the door, they passed the Judiciary Act of 1801, which creates a court of appeals. And the reason they did that is so they could appoint all these judges to the Court of Appeals. And guess who those judges are? They're Federalist judges, okay? Adams makes midnight appointments to these new courts of appeals positions. Marshall's one of the midnight appointments to the Supreme Court. He also appoints functionaries to run Washington, D.C., which is a new city and a federal enclave. So they try to stack the courts and stock all positions that they can appoint to with as many people as they can, okay? The Jeffersonians come in and they're royally PO'd. That means permanently outraged. So the first thing they do is pass the Judiciary Act of 1802, which repeals the Judiciary Act of 1801. So all those courts of appeals are gone now because the Jeffersonians removed them. They didn't want all those Federalist judges. They canceled the 1802 term of the Supreme Court, so the Supreme Court doesn't meet for 14 months as a court. And they refused to deliver some of the commissions that end up on Madison's desk, okay? So what you've got, and this is a cool political context, you have one party that's been tossed from office, okay? And Denver talked about that a good deal with the Jeffersonian, the rise of the Jeffersonians on Wednesday, okay? You have one party that's been thrown out of office, and then on its way out, it tries to hold on to some power, okay? So there's a tension with Jeffersonians. Federalist political and constitutional goals, which you've looked at before, nurturing of judicial power, facilitating broad national power and protecting property rights, all of these things now rely on the courts, okay? All of these are reinforcing goals. All of these are parts of the Federalist Party platform, if you will. Necessary to their achievements, since the only branch of the government that the Federalists still control is the courts, is judicial power. And in particular, the power to strike down legislation is unconstitutional, okay? This is still relevant today, okay? So you have this sort of dramatic political context, of which Hamilton's a part, honestly, and this context is transferable to other times in American history, okay? So let's just quickly go through those three goals because that's the crux of the presentation. Judicial power. Before the court can do anything, it has to exercise judicial power. And the problem with judicial review is that it's not enumerated in the Constitution. It's not part of all state constitutions. Some state courts had the power of judicial review in their states. Others did not, okay? So it wasn't a generally understood or received concept at the time. And finally, we have Federalist 78, which is Hamilton. Nobody knew at that time it was Hamilton, but Federalist 78 says the court does have the power of judicial review, but that's an op-ed piece in a newspaper, okay, in a persuasive argument to try to get the Constitution to be adopted. The court implicitly suggested it had the power of judicial review in a case called Hyleton in 1796, when Hyleton challenged whether or not the federal government could put a tax on carriages, because the federal government had part of Hamilton's economic program. They had a tax on carriages, and Hyleton said that's beyond federal government's power, and the Supreme Court said, no, it's not, which implies that it could have said, yes, it is, right? But it didn't exercise the authority to strike down the legislation, okay? The Constitution itself is silent on the notion of judicial review. Judiciary Act authorizes the Supreme Court in Section 13 to issue writs of mandamus, okay? Now, why do I toss Section 13 up there? Because of Marbury v. Madison. And one of the things you'll see through the course of the PowerPoint are links to cases that are abbreviated. And some of these are in the documents we'll talk about in just a few minutes. But Marshall's jurisprudential genius is to create judicial power, okay? To create judicial review, to make it part of the constitutional canon, to make it part of the role of the court, okay? So how does he do that? Marbury, as you know, involves Marbury not getting a commission. Madison comes in, sees the commission on his desk. He's the new Secretary of State, replacing Marshall, by the way, who failed to get Marbury's commission, which is also cool and part of the Hamiltonization of this stuff. Madison comes in and says to Jefferson, I've got these commissions for Federalist justices of the peace. What do you want me to do with them? And Jefferson says, don't deliver them, okay? So Marbury, being an American, does what Americans do. He sues, and he sues for his commission, and he sues under a writ of mandamus. And remember that Section 13 of the Judiciary Act gave the court original jurisdiction over writs of mandamus. So it would hear cases involving mandamus according to congressional statute. So the issue before the court is whether or not Marbury should get his commission. And we'll go through this when we look at the document. But there are three issues, and Marshall says, yeah, he should get his commission. Yeah, mandamus is the right tool to get him his commission, but we can't order that. And then the question is, why can't we order it? And he says, because Congress can't add to the original jurisdiction of the Supreme Court. It's not in Congress's authority to add to the original jurisdiction of the Supreme Court. And this is the judicial hammer. It is emphatically the province and duty of the judicial department to say what the law is. Okay? The Constitution is fundamental law, superior to all other law. Any other law that's inconsistent with it is not law. So the Constitution and no such ordinary act must govern the case to which they apply. This is Marshall seizing the power of judicial review. He strikes down the 13th section of the Judiciary Act and says Marbury can't get mandamus from us because we don't have the authority to do it. That Congress can't add to our original jurisdiction. Now, this is politically genius. And again, Hamiltonized this, right? This is politically genius. And it's politically genius because there's nothing for Jefferson to disobey. Marshall's created the power of judicial review, which does not exist in the text of the Constitution, and he's created a precedent from which to build, okay? He can use judicial review down the road. And in fact, he never uses it to strike another federal law, but he does use it to strike down state laws, and we'll see that in just a second. He avoids the emperor has no clothes problem, because if he had ordered Jefferson to give Marbury his commission, Jefferson wouldn't have. And all that would demonstrate is that the court really doesn't have that much power at all, okay? So Jefferson's outraged. He has this departmental theory of constitutional interpretation. Each branch determines for itself what is constitutional. Jeffersonians in this House and the Senate impeach and almost convict Samuel Chase and other of the justices, and that was a shot across Marshall's bow, be careful or we'll remove you from office. And then the court itself backed down when asked if the Judiciary Act of 1802 was unconstitutional. And it probably was, because judges are to have life tenure, and these judges didn't because their offices went away. But the court said that it was constitutional. Okay, so it didn't provoke a response from the Jeffersonians on that. That's an act of judicial self-restraint. All right, so Marbury creates the basis of the court's power. It can strike down legislation and limit governmental power. It can also uphold legislation and say whether or not government, they say, yes, in fact, government has this constitutional power. This power is extended over state legislation, judicial decisions by these decisions in the Section 25 of the Judiciary Act that we looked at before. All right, second goal, and we'll come back to these when we talk about the documents because I arranged the documents around these goals. Second goal, national supremacy. What do you do now that you've got this judicial power? And you're exercising judicial power in this political context, Republicans against Federalists, right? So questions that divided these guys: source of sovereignty, states' rights or popular sovereignty, scope of national power, narrow or broad, okay? How do you interpret the authority of the Constitution? Jeffersonians were more textualist, narrow interpretation. Federalists were more extra-textual. Now remember, the Federalists don't control any branch of the national government at all at this point in time, except for the Supreme Court, okay? So to their capacity to get their agenda on the national radar and to influence national politics resides solely with the court, okay? So the question is, who's sovereign? Jeffersonians said states are sovereign because they ratified the Constitution. The 10th Amendment leaves them the bulk of governing power. Federalists said the people are sovereign because the people ratified the convention or the Constitution in state conventions, which were specifically drawn from the population of the states. The preamble refers to we the people, not we the states. And the Supremacy Clause says the national government is supreme in all things it has authority over, okay? Which side did Marshall take? The Federalist side. McCulloch v. Maryland, as we'll see later this afternoon, the bank case, okay? Collins v. Virginia is another instance of this. So Marshall, through constitutional interpretation and exercising the authority of judicial review, striking down the Maryland tax, for example, in McCulloch v. Maryland, Marshall advances the notion of popular sovereignty, a notion that is still contested, by the way, and was contested strongly up until and through the Civil War, which is the Civil War because the North won and not the war between the states because the South lost, okay? So How broad is this national power? Jeffersonians say, well, it's very narrow. It's limited to the enumerated powers in Article 1, Section 8, and the rest of governmental power rests with the states. Federalists argue that the power of the national government is very broad because the national purpose which brought about the Constitution in the first place, and they said that the Constitution also contains implied powers, okay? And they point specifically to the necessary and proper clause. Marshall's answer is that the scope of national power is broad. And again, Marbury v. Madison, which we'll look at in a bit. And think of Gibbons v. Ogden, okay? Gibbons v. Ogden deals with enumerated power, Congress's power to regulate commerce. But just because it's enumerated doesn't end the question. The question is, okay, what counts as commerce? And Marshall gave you a very broad definition of what counts as commerce. And when you have a broad definition of what counts as commerce, you broaden the authority of the national government. You do what a federalist would do, okay? National supremacy, how do you interpret the Constitution's powers? Do you look at them narrowly, textually, or do you look at them more broadly, extra-textually? Marshall's answer, broadly, extra-textual. Marbury v. Madison is a classic example of this. What kind of power, where does judicial review come from? It's implied by the notion of judicial power and the capacity to decide cases and controversies. McCullough v. Maryland says Congress has implied powers to create a bank. There's nothing in Article 1, Section 8 that says it can't, okay? So those two goals are advanced by Marshall through judicial interpretation, which was made possible by Marbury v. Madison. The final goal is the protection of private property. And this transcends the American experience and goes back to the British experience, John Locke and the Second Treatise of Government, talking about property being a natural right. One of government's functions is to protect property from usurpation. And the Constitution includes property protection too. Article 1, Section 10 prohibits states from impairing the obligation of contracts. The Fifth Amendment says private property can't be taken by the national government without just compensation. So there are property protections in the Constitution. The Federalists love their property, okay? And think about the discussion of land speculation for Washington and the like at the time, all right? Madison in Federalist number 10 talks about the rights of property and the need to protect them. Hamilton in Federalist number 78 also says that part of the job of the court exercising judicial review, limiting government, is to protect the rights of individuals from serious oppressions of the minor party in the community. One of those rights of individuals, property, okay? Now, if you scale this out in terms of the political parties that Denver was talking about the other day, Jeffersonians in general were less inclined to protect private property, specifically through the courts. The 10th Amendment gives states a lot of authority to regulate the health, safety, welfare of their people, right? States are sovereign and democracy should govern the will of the majority, okay? That's the Jeffersonian position. It's not the Federalist position. Federalists were inclined to see the need for more protection of private property, both in constitutional text, in this notion of fundamental law and limited government, and also leaning on a core principle of liberalism, which is individual rights. And we just saw that in Locke and then Madison and Hamilton quotes, okay? Guess where Marshall comes down? More. Fletcher v. Peck, Dartmouth College v. Woodward, okay? So, Marshall situates the court in American politics. He has enormous success, okay? He advances the Federalist agenda in an environment hostile to the Federalist agenda. And as the Republicans held power longer and longer, they became less suspicious of the national government, more inclined to use it. Madison was the one who signed the bill for the Second Bank of the United States, for example. That's the issue in Marbury or McCullough v. Maryland. So Marshall had phenomenal success over a course of 35 years. Remember, 3 Chief Justices the first 10 years, 1 Chief Justice for the next 35. He put a strong imprint on American constitutional law and the way Americans think of and conceive of judicial authority. But remember, Federalist number 78, the courts have neither sword nor purse. They simply have the power of judgment. Ecclesiastes 3, 1 through 8. For everything there is a season. Turn. The lesson is that the court must be judicious in the exercise of its judicial power, because it has to persuade other branches to go along with it. And we'll talk a little bit about this one with McCollum. I've already talked about it with Marbury and Stewart. Marshall's genius was in part not giving Jefferson something that he could slap down, that he could disobey. And as long as Jefferson couldn't disobey it and other presidents couldn't disobey it, then you're asserting judicial authority, okay? But if you aren't judicious, and this is Worcester v. Georgia and then Dred Scott, if you're not judicious with your use of judicial power, then you're going to get disobeyed. And people will realize that your power is ephemeral and that the emperor really has no clothes. Marshall was incredibly good, with the exception of Worcester, of picking fights that he couldn't win, okay? Marshall knew and tended to the limits of judicial power. In doing so, he became the model Chief Justice. If you see anything with John Robertson, the current Chief Justice, he's in the PBS Supreme Court series, for example. John Marshall is his hero. He is patterning himself on what he thinks John Marshall would do, okay? And you may see some of that in recent decisions of the court, okay? So, why Marshall? When you're talking about the establishment of the federal judiciary, great Chief Justice, great constitutional force, great steward of the role of the court. In Marshall, you see the fusion of constitutional law and constitutional politics, law and politics, in this dramatic political context. His genius was understanding principle and its relationship to the art of the possible. In a very real way, John Marshall invented the Supreme Court and the federal judicial system, okay? Now, what we're going to talk about when we look at the documents after the question and answer period is how to make Marshall interesting, to contextualize him, to humanize him, to Hamiltonize his story and the story of the federal courts. And then how you make signal constitutional decisions interesting by simplifying them and contestizing them. Because this helps make our heritage, our history, real and relevant. And if the events of the last 3 weeks since the murder in Minnesota tell us nothing else, they tell us that the past is simply a prelude to the present and a springboard into the future, okay? There are some useful websites that you can go to. Those are your STAR standards, the ones that are implicated by what we were talking about here. And that's Handsome John. So with that, I will stop sharing my screen and open it up for questions.